Good morning, everyone. Welcome to the September webinar for the Mortgage Quality and Compliance Committee. My name is Susan Milazzo. I'm with the California MBA, and I welcome you to today's event. I will turn it over to our chair in just a moment, but I want to remind you that you are all entered in on mute, but you do have an opportunity to pose questions to our speakers through the questions dialog box at the lower right hand of your screen. And at the conclusion of today's presentation, we will go ahead and address those questions. This webinar will also be recorded and will be available on the California MBA website by tomorrow afternoon. And with that, I would like to start us off with our today's agenda, and I will turn it over to our chair, Marty Allred with American Pacific Mortgage. Marty, I'll turn it over to you.
Hi, thank you, Susan. Hello, everybody. Good morning. Hope that your day and your month is going well. My name is Marty Allred. I'm Vice President of Compliance for American Pacific Mortgage Corporation and the chair for the Mortgage Quality and Compliance Committee. We have a lot of people on the call today. Thank you so much, everybody, for joining. Our main topic today, advertising and social media compliance, continues to be a hot topic. So I imagine that's why we have such great attendance. But we love seeing everybody on the call on these webinars, and please keep coming. Invite your friends and your colleagues as well. It's hard to believe our last webinar will actually be next month for the year. And that's going to be on October 25th, and the topic will be e-closings. So we hope that you'll join us for that as well. The Mortgage Quality and Compliance Committee takes a break from the webinars to provide some assistance to the California MBA Legal Issues and Regulatory Compliance Conference, which is coming up in December. That's going to be on December 3rd and 4th in Newport Beach. You can register for that now on the cmba.com website. Go to the events section, and again, we hope that you register. Let your colleagues know about that, and we look forward to seeing you there. There are also a couple of other events that we want to make you aware of. Again, you can always find the events on cmba.com. Go to the events area. But we always have great networking events that Susan and her team put together. There's a networking event at the offices of Equator in Irvine on October 11th, and then another networking event at the offices of EarnUp in San Francisco on October 25th. So you can go to the website and register for those now. Again, our featured topic today is advertising and social media compliance. But before we get to that with our great guest speakers, we have our regular fantastic speaker to discuss our California legislative update and keep us in the know with what's going on at the legislative level. And that is, of course, Pat Zenzala, who is the California MBA lobbyist with KP Public Affairs. Pat?
Thank you, Marty. Can you hear me okay?
Yes, I can hear you.
So first, before I start talking about bills, just to give you a sense for where we're at in the legislative process, the good news is the legislature ended their two-year session at the end of August. So they will not be meeting again until December, and then only for a day or two to swear in new members that are elected in November, and they'll begin the next two-year session in January. And we're in the process now of waiting to see what the governor is going to do with all the bills that passed. Literally hundreds of bills have passed in the last week or so of session. And he has until the end of September to act on those bills. So just a few more days and we'll be done with the 2017-18 session. I want to talk about three bills of note for our members. The first one passed and was signed into law. It's chaptered already, as you can see on the screen, SB 818. And this is a bill that reinstated some of the provisions of the California Homeowner Bill of Rights that sunset at the end of 2017. Basically, these are the provisions that apply to mortgage lenders, servicers that have had more than 175 foreclosures in the previous 12-month reporting period. So this bill will reinstate them as of January 1st. The good news with this bill is we were able to actually amend the bill to place some positive amendments that are helpful to mortgage servicers and lenders in California. The first is to try to make this law more consistent with CFPB servicing rules. So it creates a 5 business day cutoff for applications for modifications prior to a foreclosure sale. So an application for a mortgage loan modification would not be deemed would be deemed incomplete, I should say, unless all the documents required by the servicer are received 5 business days or more before the scheduled foreclosure sale. So that helps to stop situations where you receive the application up until literally the day of the sale. And then the second beneficial amendment that we were able to get in this bill clarifies that the pre-notice of default, the telephone due diligence outreach requirements in California statute prior to doing the NOD can be satisfied if a borrower sends a written notice asking the servicer to cease communications with the borrower. And this helps to remove a potential conflict with the Federal Fair Debt Collection Practices Act, where a consumer says, "Stop contacting me." So both of those amendments are put in place and once again take effect in January 1st of 2019. So the next bill I want to talk about is SB 1121. Once again, it was signed and into law and chaptered. This is one that we were all anxiously waiting for, and this is a follow-up to the California Consumer Privacy Act bill that was enacted, AB 375. SB 1121 makes some helpful changes. AB 375 passed so fast, literally within 7 days, that there were a number of changes and clarifying amendments that could not be made, and SB 1121 makes those. From our perspective, there are 3, I would say, primary changes that it makes. 1, it expands the exemptions in the bill. 2, it makes some clarifying changes regarding the private right of action in the original act. And then, importantly, it delays the implementation. So, first change, the Gramm-Leach-Bliley, basically what the bill does is it takes an exemption in the original act that was not helpful, and expands it out to cover any personal information that essentially is covered by the Federal Gramm-Leach-Bliley Act, implementing regulations, and the California Financial Information Privacy Act. So information covered by that act is exempted from the requirements of the Consumer Privacy Act. So that's 1. 2, it makes it clear that the private right of action in the act only applies in situations where you have the security breach provisions of the bill. So it doesn't apply, the private right of action is limited only to actions arising out of data security events, as opposed to all of the other violations under the privacy obligations for the act. So that was helpful. And then the final thing, once again, it changes the implementation dates by providing the California Attorney General with a 6-month extension to write implementing regulations. So until July 1st, 2020, I should say, and by barring the AG from bringing an enforcement action until the earlier of July 1st, 2020, or 6 months after the AG has published the final regs. So the next bill I want to talk about is SB 1201. And this is a bill that was sponsored by the Department of Business Oversight. And it basically takes existing statutory requirements for origination of mortgage loans, where you negotiate primarily in Spanish, Chinese, Tagalog, Vietnamese, or Korean. And if you do negotiate primarily in those languages, you have to provide a boilerplate form supplied by the DBO. This bill expands it to dealing with mortgage loan modifications. So if you are negotiating a modification primarily in one of those languages, you would go under the bill to the DBO, and they are going to be translating several existing Fannie Mae documents in these foreign languages, and you would just pull down those documents, and you would have a safe harbor from as far as the requirements of the bill, as long as you use the documents provided by the DBO. And then the other thing that the bill does is it updates some of the existing forms that the DBO provides translations for, as far as on the origination side. And this bill again takes effect. Actually, if I remember correctly, it has a delayed effective date 90 days after the forms are available from the DBO. But the DBO says that they are going to be getting these forms on their website, I think in the fall, winter of this year. So hopefully they'll be available very soon. That's it as far as issues that I wanted to mention.
Okay, great. Thank you so much, Pat. Could I just ask a clarifying question on the slide that's still up regarding the foreign language disclosures? Did you say that this applies to loan modification disclosures, or to upfront disclosures for originations as well?
So this bill, the primary change is it now would be providing the translation requirements to mortgage loan modifications.
Okay.
And the DBO is going to provide those forms, but it also updates the forms, the existing forms that are used on the origination side.
Okay, great. Good to know. And then it sounds like the effective date is to be determined based on when they have those forms available. So we'll all need to look for updates on that, because it sounds like it's effective 90 days from the time they do that, right?
That is my recollection. Sorry, I don't have the language in front of me, but that's what I remember.
Okay, great. Well, thank you very much. These are very timely updates, and we appreciate all the hard work that you and your team does to lobby for these, and also for the benefits that are obtained for the lenders and servicers in some of these, the language of some of these bills. I do want to point out that, some of these topics may also be some of the topics that are addressed at the Legal Issues and Regulatory Conference in Newport Beach in December. I think the topics are still being worked on and finalized, but especially the California Consumer Privacy Act is a big topic, and one that everybody will need time to figure out how to best comply with that. So we appreciate the legislative updates on that. Thank you, Pat.
Sure.
And we're going to go ahead and go on to our feature topic today. Again, we're going to hear about advertising and social media compliance. And we have two great guest speakers to delve into this information for us. First, we have John Jaffe with Mayer Brown. And John is a partner in Mayer Brown's Palo Alto office, and he's a member of the Consumer Financial Services Group. He works with banks, savings associations, mortgage bankers and brokers, consumer and commercial finance lenders, real estate professionals, and e-commerce companies. John advises clients on general corporate law, mergers and acquisitions, commercial real estate, consumer and commercial lending, and secured transactions. He also counsels clients on matters involving e-commerce and electronic delivery of financial services. John's also a frequent lecturer at seminars and conferences sponsored by financial services trade associations, and he's written articles for a number of publications on the legal aspects of lending and the internet. And his full bio is available at mayerbrown.com. In addition to John, today we have Pamela Fleckser. And Pamela has been in the mortgage industry for over 25 years. She has experience in all aspects of loan manufacturing, with a focus on compliance, internal audit, and quality control. She has managed quality control for several mortgage companies, where she was also the main contact for external audits, including the DBO and CFPB. She's currently the Director of Audit and Quality Control for Loanpal, which is a DBA of Paramount Equity Mortgage. And in this role, Pamela is the chair of the Credit Risk Committee and the Fraud Committee. She's been a member of the Association of Certified Fraud Examiners and the creator of Insight Beyond the 1003, a comprehensive quality control plan. Pamela is also a member of our Mortgage Quality Assurance and Compliance Committee for the California MBA. So Pamela and John, we're excited to have you and hear what you have to tell us and teach us about advertising and social media compliance. Pamela.
Hi, thank you for having me. Welcome, and let's talk about some really fun subjects with social media and advertising compliance. I had to share this image as I feel this really explains all the different various social media and how it applies to our world. So I thought this was kind of interesting, especially, you know, the I Like Donuts on Facebook, which is, you know, one of the biggest social media means that we are using today. So I'm going to go ahead and get started on the background of social media compliance, and let's talk about why this matters to us as lenders. So the Consumer Compliance Risk Management Guidance that came out from the FFIEC, which is also used as a supervisory guidance for the CFPB, also now known as the BCFP, states that a financial institution should have a risk management program that allows it to identify, measure, monitor, and control the risks related to social media. The size and complexity should be commensurate with the breadth of the financial institution's involvement in this medium. The risk management program should be designed with participation from specialists in the compliance, technology, information security, legal, human resources, and marketing, and include training for employee official use of social media. And I think that really tells us, you know, that it matters. And so we've, as the last few years, have been going through and identifying ways that we could best monitor social media. And I'm going to talk about, in my experience with working with several lenders, of some of the common pitfalls, some of the areas that I think we could apply some best practices, and definitely share some fun examples. So the risk management program, so this kind of gives you some additional definition of what is expected of us. So the first being an employee training program that addresses policies and procedures for official use of social media and defining non-permissible use. I think that's important, and we're going to talk more about that as I go through the presentation. Policies and procedures for regarding the use and monitoring of social media and compliance with all consumer protection laws and regulations, methodologies to address risk from online postings, edits, replies, and retention. A structure to govern with clear roles and responsibilities that include the board of directors and senior management on how to use social media and how it contributes to the goals that include advertising, brand awareness, researching a new customer base. This would also establish controls and ongoing evaluation of risk in the social media area. A risk assessment procedure for selecting and managing a third-party relationships associated with social media. And again, we'll go into that a little bit further. The risk management program will also need oversight process for monitoring information posted to proprietary social media sites administered by the organization or contracted third party. Compliance and audit functions to ensure ongoing compliance with internal policies and all applicable laws, regulations, and the incorporation of guidance as appropriate. Parameters for providing appropriate reporting to the organization's board of directors, senior management that enable periodic evaluation of the effectiveness of the social media program and its meeting of its objectives. So what does that mean? So let's take a look. So this is a great image that kind of shows all of the social media. I think as we hear the word social media, a lot of times Facebook is what we're thinking. There's so many other various social media entities. We've got Twitter, YouTube, Instagram, Google+, LinkedIn, Pinterest. I did see that, you know, the biggest social media on the internet in both terms of the numbers of users and the recognition of names is Facebook. So I am going to talk a little bit more about Facebook in particular. So this is a great little graph to show if people are on social media platforms, what platforms are using. I think it's interesting to see that 90% of LinkedIn users also use Facebook. This source came from social media use in 2018 from the Pew Research Center, and it just gives you some ideas as to people that may be on one platform and how much they're using others. I do think that the people that are using Facebook are also using several other social media platforms, so that's important to know as far as you know, who is being seen and who are the users of this particular social media. Let's talk a little bit about the risk of non-compliance. So there's compliance and legal risk for potential non-conformance, violations of laws, regulations, internal policies and procedures, ethical standards, or practice. I think, you know, these can result from where organizations and policies and procedures governing certain products or practices may have not held up with the changes in the market. And I have seen this when we're applying an internal audit to a mortgage company where the changes are practices are changing, I should say, but the policies and procedures are not keeping up with those. For example, if I'm out doing an audit and interviewing staff, I would find that there are additional social media platforms being used that were not addressed in our policies and procedures, so they were not being monitored. So that is definitely something to keep your eyes on. And again, ongoing monitoring of social media sites would help us know that. But as we know, we can't always monitor all of those. So this was a situation where, you know, Instagram was being used, and I don't think the company was aware that their staff was using Instagram for business solicitation. Reputational risk can result from negative public opinion, which could be associated with the employee use of social media. As we know, this should be monitored closely. And in some cases, I have seen that this is encased within a compliance or a complaint department, or I've also seen this actually being monitored by a marketing department. And just something to keep in mind if we are going to use a marketing department to monitor any kind of negative public opinion that's out on social media, you know, does that marketing department have the training in order to address complaints in a manner that we would be sufficient for regulators? So I think that's something to think about when you do have negative public opinion out there. There are multiple sites. Obviously, we know of Yelp as one of them. There's some other ones I came across, yellowbot.com. There's many ways that people can put negative public opinion out there. It could be on an employee, it could be on the company. I think it's all important that they're addressed in one way or another. There is additional risk for failure to address issues, which could expose the organization to potential enforcement actions and/or civil lawsuits. So obviously, that's one of the bigger concerns, and that is something that I feel we're all looking to avoid and making sure that we are monitoring to the best of our abilities. So some of the common pitfalls that I've come across in auditing this area with social media is, you know, loan originators being featured by realtors' web pages and some kind of a joint venture website, which may not be compliant. In many cases, I have seen these where NMLS IDs were missing, or even such fun things as photos of loan officers being swapped and the wrong photo being shown. So I have definitely seen that when there is an outside party managing these websites that are featuring your staff, those are not going to be as regulated, and it's something that you have to be aware of that could be out there and could be of concern. Certainly sales staff of social media with claims such as the use of terminology that includes EST, so best, fastest, lowest, the use of terminology that is a violation of federal advertising regulations, specifically counselor, neighbor, bank, or free, quoting non-compliant interest rates, non-disclosure or affiliation with company when disclosing content related to the industry or company-specific matters. You know, that's kind of a mouthful, but there's definitely some Great examples. I have seen loan officers state things like, I'd most likely be your best bet. I'm a banker, I have a broker's license and plenty of good reviews. Come talk to me. That is, examples I have seen over and over again. So again, the use of the terminology is very important in making sure that your staff is trained as to what is appropriate and what is non-permissible. The use of a business name or loan originator name without the required NMLS identifier. This I have seen is probably one of the largest issues. Websites that are featuring loan originators without their NMLS ID, and or how many clicks does it take to get there? So in the case of Facebook, is it right there with their name, or is it in their section that says about, and it may be 2 clicks in before you see the NMLS ID? These are all things to be aware of, and what is your company's risk for or appetite for risk as it comes to that? Do you want that NMLS ID right there next to the loan originator name, or do you want it to be further into the page? And what is the comfort level there? So some things to look into and to address in your policy and procedures. Additional common pitfalls: loan originator titles not consistent with actual titles. This is something that I have seen a lot with LinkedIn, and sometimes people don't keep their LinkedIn up to date, and maybe they're with another company and they have switched companies, and these are all things that we definitely want to make sure the actual title is being used and they are not elaborating the title, which I have seen. Loan originators with dual employment being discovered. In searching for sites and or staff, such thing as even Googling your staff, we have even found over the years loan originators that are employed somewhere else that is a conflict, and they were not aware of this. It was not revealed to the company. So these are all things that have been discovered upon doing some online searching. Providing marketing materials not approved by your company or social media pages. So in my experience, most companies do have a process to get marketing materials approved, and it can be then presented on social media sites. It's very difficult to monitor all of that, and I think that is something that you want to talk about in your policy as to how you are managing and monitoring that site or those materials from going out that makes to ensure that they are approved. But I have seen several examples where marketing materials are out there on the web and they grab them and they have posted them without the applicable approval by the company. Again, NMLS teams, when you have a partnership with 2 loan originators, I think they tend to forget they need to also have their NMLS ID. And in this situation, I have seen that come up a few times where there is a partnership and they do not have their NMLS ID on their particular sites. Videos being shown on social media, also not approved by your marketing department. And I think that this is an example I have in this area would be a loan officer sitting with a realtor that they have been working with and talking very candidly about their business, where the realtor calls them a mortgage broker, and they're not a mortgage broker, and that video being posted on social media. That's kind of what I'm referring to. Obviously, there's a lot more social media videos that could be posted that may not be approved, and I think some of the things to think about as you're going through your policy is really, what do you want? Do you want a specific Facebook page for individuals to have socially versus professionally, or does your company allow them to have both? And if they do, what are those parameters around them? Prohibited posts by your on shared social media. So is this clearly defined by your company? I have seen this where the word maybe that's been used as extreme. Well, what does extreme mean to your company? What types of social media posts are allowed on business or professional soliciting social media? Maybe profanity is an area you want to address. Can you have a site that, you've got your social posting happening and then the next site is come check out my open house? Those are the kinds of areas I have seen where you need to address that clearly in your policy. State exams. State exams may interpret a social media post stating that an individual works as a loan officer as a solicitation, and that same is viewed differently in other states. So just something to keep in mind, that whether or not they're actually soliciting business, if a loan officer stated that they work as a loan officer, that is enough for certain states to deem that site as a solicitation. So something to keep in mind, that it is state specific, and you would want to definitely keep your eyes, be aware of those requirements. The use of borrower MPPI on social media pages. Is this acceptable? Do you have permission granted by the borrower? So I've seen several companies that use a survey company. After the loans are closed, they reach out to the borrower and they ask them some questions, and if they've got a great review, then maybe they will post that on social media. So something to look at on this piece is, do you have permission to post that by the borrower, is the first step. The second step is, what is your policy on providing the MPPI information? Are you tagging those borrowers in that post? Are you seeing the terms of their loan? Are they sharing that they had very little down and they had this great experience? Those are all things that want to be very much aware of. So just to circle back, specific questions to address in your social media policy. What are the company's social media monitoring tools or techniques to identify heightened risks and respond appropriately? That's definitely something that is lacking in many of the social media policies that I've seen. How are you monitoring it? Do you have a third party? Do you monitor internally? And what are you doing once you find issues? Sometimes you can find an issue and you have difficulties actually addressing them. And what is the next step? So do you have an HR involvement? What is the next step when you have that come up? Is there any monitoring provided by a third party? And if you are using a third party, how are they monitoring? There's lots of different monitoring companies out there. Some of them are kind of a la carte, and they have very vast variety of monitoring, but you have to provide them a lot of information. Maybe you have to provide all of your loan originators, or you have to provide all of the sites that you want monitored. And if there is a individual site, may not be one that we have available. There may be an individual loan originator site that you may not be aware of. So is it better to go with another third party that does more of a human search? There's human involvement where they're looking on Google and they're Googling your staff to see what is out there for social media. Are there other types of ongoing compliance monitoring on social media internally? So do you have somebody who goes out and does these searches for you through the company periodically? And what are they doing? What are they searching for? Do you have a risk profile or a risk management program completed for social media as recommended by the CFPB? Also, do we make solicitations using eligibility information or respond to direct disputes in connection with the loan eligibility using social media? And if you are, there's additional FCRA requirements, if so, per the CFPB. So in recommendations and best practices for the social media, we want to ensure that your employee training program addresses the use of social media and clearly defines the non-permissible use and expectations. I think this is really important. I have interviewed loan officers where they were not provided that training. Maybe there's a policy on it, but they weren't aware of that policy. Training is super important when it comes to social media, and really giving some great examples as to what is acceptable to your company. One option I have seen is offering a company-monitored business social media that is maintained by the marketing department to ensure compliance with applicable laws, regulations, and the company policy. And it would keep separate personal interest posts separate from the business advertising. So I have seen that as an option that seems to work well. Again, if you are going to allow the merged business and personal, you really have to define what is prohibited and permissible if you are going to do that and allow that. Another recommendation is to employ a technology solution or internal self-assessment that provides the monitoring and feedback when appropriate language is used on social media. This is something that I think is great, whether or not you are using a technology solution or not. I think the monitoring piece is obviously key. And again, I think on the monitoring piece that we don't have to monitor all of our staff all of the time, but what I do think we need to do is to have periodically test and monitor of the social media sites and ensure that you are seeing information constantly, but there are ways to just do portions of your staff, and I feel like that is one way to just kind of keep on track. And then also, if you are using a third party, it's important you're performing intermittent reviews of the vendor's performance, similar to your organization's review process. So is the vendor really doing what they say they're doing? Kind of the auditor mindset is to make sure that they are performing those searches on the same numbers you're expecting, just to ensure that you're on the same page. All right, so let's change tunes a little bit and let's talk a little bit about advertising. So advertising is considered a commercial communication, which may be written, oral, illustration, or depiction that is designed to effect a sale or create an interest in purchasing goods of sale, whether it appears on or in various mediums. Here's kind of an image of the various advertising means. And I think advertising has got a lot of attention over the years. I think it's important that we have a program in place as in any mortgage lender shop that we are looking at the advertising to ensure compliance. I think consistency is important, and having an approval process for all advertising is essential, but is it documented? Is there a checklist to ensure consistent compliance reviews? Is the person approving the advertising reviewing the same things on each piece of advertising? How do you monitor that all advertising is approved by the appropriate channels and record retention is maintained? Again, I think that's something that I have seen lenders fall short in those areas. Do your policies and procedures detail your company requirements as to the process? What is the process to get something approved? How does it get published? How does it get approved? It's important. I've seen policies and procedures out there where it stated everything had to come to a particular email address, but then in practice, that's not what they're actually doing because, we've done it for so many years. We just kind of send it to this person and they approve it and we move forward. It's important that, it's detailed and the policies and procedures are your current practice. Also, is this addressed in your new hire training for loan originators? It's, again, same issue as the social media. Is this something that you're going over when loan officers come on board as to what the expectations are, not just for social media, but advertising in general? Common pitfalls. So in reviewing advertising over the years, I have found diversity in your photos used for advertising. At several companies that I have been with seems to be something that isn't always on task. So I think that's really important that you are looking for that piece. Processes defined or outlined in your policies but not being followed. I kind of mentioned that with, addressing your process for approval and then finding that's not actually what's occurring. And then equal housing lender and equal opportunity lender logos. That has been an ongoing trend that I have seen. The logo is not large enough. It's not legible. Which logo are you using? I mean, I think there's been a lot of back and forth on this piece. And then the obvious piece is the trigger terms under TILA. There's so much that go around the trigger terms, and if you are noting the amount of down payment, the number of payments, or the period of repayment, the amount of payment, the amount of the finance charge, then you've triggered additional disclosures, and you need to make sure that those are including the amount or percentage of the down payment, the terms of repayment, the annual percentage rate. So again, trigger terms are kind of the basics when it comes to advertising, and I think we have to be careful with false claims. When they are stating, I'm the best loan officer and I can close your loan in 5 days, can you really do that? I think false claims are out there as well, and it's something to be aware of. So to move on to best practices, I think identifying all areas of marketing, including those being used in social media, ensure an approval process is in place and being followed, monitor for new areas of marketing with open communication, define change management process and possible spot checks. I have found in one case that there was a rate sheet being provided to an entire department and the marketing department was not aware of that. It was coming from the sales side and they were using it and they were sharing it and it wasn't being approved in the proper channels. And again, keeping the policy up to date with current processes. One thing that's important is the record retention piece. Who in your company is maintaining copies of all approved advertising in all mediums? Is it the marketing department? Is it a compliance department that's doing the review? Who is responsible for maintaining the records of oversight of the social media compliance? So again, make sure that that's clearly defined in your policy and that it's being practiced. Here's some references just to kind of give you some additional information as to the guidance for social media and also the National Labor Relations Board. John, I believe this is your turn.
No, John, we can't hear you. Are you on mute?
Sorry, I was on mute.
Donna,
there you are.
Okay. There you are.
Okay. What is happening? Let's see if this will do it.
There we go.
Okay, finally, thank you. I am going to try to cover some of the areas that Pamela didn't. Pamela, we decided should go first because she's feet on the ground and sees on a day-to-day basis some of the issues that arise in social media usage. I'm going to go through this fairly quickly because we're running short of time, so don't feel cheated. You will get the deck if you want it, and I will try to highlight those issues that are most pertinent and skip on some of those that are less pertinent. There's my cute little comic. Okay. If you take nothing else away from today's webinar, this is the one. Social media is advertising. It should be treated the same as any other advertising that you use. Well, that's not exactly true. There are some nuances that apply in social media that don't apply in newspaper ads, magazine ads, billboard ads, etc. But it's advertising. So apply the same principles and guidelines here that you would in connection with your other ads and marketing materials. It's regulated at both the federal and state level. At the federal level, you've got the FTC, which has the authority to regulate advertising. It's got to be truthful, non-deceptive. You have to have the ability to back up your claims. That's similar to what Pamela was alluding to. If you're saying it's the lowest rate, then you should be able to prove it's the lowest rate. You can perhaps say instead it's one of the lowest, but if you say it's the lowest, some regulators are going to say you need to prove that. And of course, you can't have ads that are unfair or deceptive generally. State AGs can also enforce this, and most states have acts similar to the FTC Act. California has two. It's got the Consumers Legal Remedies Act, and it's got our version of UDAP, which is 17200 at SEC, which prohibits unfair and deceptive trade practices. So claims for misleading advertisements and marketing materials can be brought under either in theory. Okay. FTC has recently updated some of its guidance relative to consumer endorsements, employee endorsements, disclosures on Twitter when you're endorsing a product, like-gating and social media contests, and I'll try to go through those real quickly for you. So why does it matter? Because the FTC is concerned that if an individual is speaking about a product, that people will give credence to that speech if they think that individual is independent. If, on the other hand, they believe that that person is affiliated or associated with the company whose product they're endorsing, less credibility. So the FTC essentially requires disclosure any connection between a seller, such as a lender, and somebody who's endorsing that seller. Okay. Some of the things to consider. Did you as the lender pay the endorser? Did you provide the endorser any free products or services? Did you give them discounts, for example? Is there a relationship with the endorser? For example, are they an employee? Are they a business associate of the company? And are they speaking independently or are they speaking on behalf of the company? I'm going to back up for a second. So there's been a lot of stuff in the press about bloggers and bloggers who are paid to endorse certain products, and the FTC's been all over that. That's just one example. Okay. So what are some examples of disclosures or statements that require disclosures, such as the lender gave me a discount for this review, or the lender compensated me for this review, or I'm an employee of the lender. There are specific disclosure issues relative to different social media platforms. So for example, on Twitter, you could say hashtag paid or hashtag ad, and that might be sufficient. If you're getting a testimonial, and I'm focusing on testimonials because we've seen a fair amount of consumer testimonials on clients' websites recently. So if they are endorsing your lending product or service, they got to be an actual consumer, one of your actual borrowers. They're supposed to reflect the typical experience of your borrower. So if you have 50% of your people come in complaining and you pick one that's a glowing endorsement, that might be problematic. Most importantly, I think, the FTC recommends that employees check with their employers before posting anything online, including on social media, if they're posting about their company's products or services. And this again goes back to what Pamela was talking about. That's to ensure that your employee who's posting on a social media website is not violating one of your policies. Skip that. Now, are you required to track or monitor your employees' activities? No. Can you? Yes. We'll get to that in a second, I guess. Subject to some limitations. As Pamela said, you should absolutely establish formal policies for employee endorsements and for employee use of social media sites. Here's an interesting one. And by the way, everybody will see that I said 140 character limit on Twitter. I understand it's now 280. I apologize for that. I'm old. That's my excuse. The FTC has not mandated specific wording to be used for endorsement disclosures on Twitter, but it has said that the same concepts governing sponsored statements apply to endorsements on Twitter. How do you get that in a 280 character limit? It's pretty difficult to do. The FTC has said that the following are likely to be effective. So if you use words like sponsored or promotion in a tweet, that should work. Or if you begin the tweet with hashtag ad, that should be sufficient. However, you can't use abbreviations or contractions that aren't clear, such as hashtag SPON for sponsored. For Instagram, putting hashtag ad in the first comment is not sufficient. The disclosure needs to be in the description. Again, this is according to the FTC, and these aren't absolutes. These are their suggestions. FTC provides that consumers can write about their opinions of products so long as they are not being rewarded for doing so. If they are being rewarded, again, they have to disclose that. Like gating. Now, I know that Facebook no longer permits light gating, but it's still something that's being done on other websites, and there are people who get around Facebook's prohibition by doing action gating, if you will. What's light gating? That's where you would require a consumer to like your product or service or your web page before they can move on to your content or before they can enter a contest, for example. In any event, I use light gating in a broader sense, just where you are having people like your product in various ways, even if it's not necessary to get through to new content or prizes, etc. Obviously, fake likes are a no-no. They're prohibited. You can't be having people go onto your website or Facebook or anything else and say that they like your product if they're not people who've actually not used your product or service. The FTC says fake followers are also prohibited, so that you don't want to puff up your presence on the web, if you will, or on a particular social media site by having a lot of people who are not followers register as followers. Copyright issues arise fairly frequently, believe it or not. So, for example, if you wanted to take user content from a social media site and put it on your website or post it on another social media site, can you do that? Well, you might be able to, but you have to be aware and concerned with potential copyright infringement. I put on the slide one example. In a newswire that was obtained, that obtained photographs from Twitter, they then published the photographs without the photographer's permission. The court held that the newswire committed willful copyright infringement by distributing the photo. So the same thing, if you are going to social media website and you find content that you like and you want to use, you have to be careful about using it. You want to be sure that you're not going to run afoul of copyright law. Same thing goes for using online reviews. So let's say you found an online review that you thought particularly helpful. You need to look at the website's terms of service to see if that user content, that online review, is acceptable for you to take and use elsewhere. Okay. Compliance with mortgage laws and regs. Pamela went through a bunch of that. I'm going to highlight real quickly National Labor Relations Act, Section 7, which most people associate with unions, isn't just applicable to unionization. It applies to any right to engage in concerted activities. It involves comments concerning terms and conditions of employment. And this goes to your company's social media policy. So you can't have something in your policy that essentially prohibits your employees from commenting on the terms and conditions of employment. Let's see. So what would be unlawful? You can't have something in your social media policy that prohibits your employees from talking about working conditions or restricting communications with outside parties. What is lawful is you can restrict them on discussing performance of the company's products or services, or privilege to proprietary information to your company, or posts that would violate federal or state law, such as libel, slander, defamation, or posting in the name of the company when it's not the company actually posting, but the employee. Skip through that because Pamela covered it. RESPA, we all know Section 8 of RESPA and what it prohibits. How does this apply in a social media setting? Well, you can have, let's see, things like lead generation on a realtor's website that may be a social media website, and where you are essentially paying, or the company is paying, or one of your employees are paying the real estate agent for, quote, social media access or access on the realtor's webpage. That's a pure RESPA Section 8 analysis. Is it truly for the advertising or marketing space that you are paying them, or are you paying them for something else that might be prohibited under Section 8? And just so we have a little bit of time to answer, I'm going to skip through. Yep. Just give us 5 minutes to take Q&A, Susan. And I'm sorry for having to rush through that, but I did want to leave some time for question and answer.
Yeah, no, thank you. Thank you for that. And we will have the recording for this webinar, which is first couple questions. We will have a recording of this webinar available on our website probably by tomorrow afternoon when we get the recording. So you will be able to share this with, revisit it or share it with others who are in your on your team. One question is, I would like to know, when the equal housing and equal opportunity lender logos are used, which do you use if you're a mortgage broker or lender? Someone want to field that one?
Pamela, you want to try?
Do you want to take that one? I would like the attorney to answer that question.
I think I'm not sure that there's a distinction. There's one logo, so I'm not sure what the question is when they say which one should you use if you're a broker or a lender. There's actually one equal opportunity lender logo in various formats, but it's the same logo.
Okay. Here's another question. Can disclosures be baked into a photo in a post, or do they have to be in the text?
That's a good question. The FTC says that, for example, in Twitter, you can't do it via a link. Some state licensing agencies say you can't do it via a link. It has to be prominent, it has to be clear, it has to be conspicuous. So the question is whether, if it's, how it's presented, is it readable to the consumer who's looking at it without having to click through to something else? I guess that's the way I'd frame it. But I'm interested in Pamela's answer too.
No, that's exactly what I was going to state is, again, is it prominent and is it something that you can read?
So we did get in our Q&A dialogue, Basha says someone had submitted that there's actually the Equal Housing Opportunity logo for non-depository institutions under the FH Act, Fair Housing Act. There's also an Equal Opportunity Lender logo that appears to be primarily used by FDIC regulated entities, i.e. depository institutions. So that might be some additional information for relative to the previous question. Another question that's posed, in regards to monitoring advertising, do you think providing resources such as checklists to marketing would suffice for compliance having to approve all marketing?
I can comment on that one. So I would say that what I have seen as a best practice is the compliance department provides some training to the marketing department as to the items to be looking for, and then yes, I could see that could be a good solution for you.
There are various levels. You can have it so that it's detailed and you or legal or compliance has to review everything. That, of course, is not terribly workable. Or you can have written policies and procedures that include checklists, much more workable. And then you can have what Pamela referenced, which are third-party monitors that you can pay to monitor your company's employees' social media websites or web postings to see if they all comply. There's no perfect answer. It's really a balancing act at the end of the day, which works best for you.
I've also seen templates used, which have been helpful. If there's a particular template that's going to go out more than once, and if they approve that template, I think there's a little bit more room for having somebody in marketing approve it, knowing what the particular compliance requirements are.
Yeah, I think some social media sites like Twitter, very problematic if you're using them for marketing. I just don't see how you get everything in that you want to get in without essentially ruining the message that you're trying to convey.
Okay, well, if anyone has any other questions, please go ahead and submit those in the questions dialog box. That I have fielded all the questions that we have so far. So I would like to thank both John and Pamela for their presentation today. Very helpful information, always something to be revisited, as there's always new people coming into the industry, and I think the ongoing, education about what's allowable on social media and advertising is always a good topic. As Marty mentioned earlier, certainly something that will be covered at our Legal Issues and Regulatory Compliance Conference in December. As far as next month, which, as Marty also stated earlier, is our last mortgage quality and compliance webinar for 2018, we'll be covering the topic of e-closings. And we have Representative Jeff Bode from Mid-America Mortgage and Brendan Weiss from MERS will be our presenters on that webinar. So with that, I want to thank everybody for joining us today, and we will hope that you will join us again in October. Have a great rest of the day. Thank you.